Well, we're now going to hear a closing statement on behalf of the Local Authority Building Control by Mr. Dominic Adamson, Queen's Counsel. So, Mr. Adamson, take your place at the lectern and begin when you're ready. Thank you.
Good afternoon, Mr. Chair, Mr. Stefan and Mr. Akbor. ABC wishes to begin this statement by once again expressing its sincere condolences and apologies to the families of those who perished in the Grenfell Tower fire, to the survivors of this tragedy, and to others affected by it. LABC intends to address you today, and it has 6 points that it wishes to make. First, the evidence in Module 6 has conclusively demonstrated that there was long-standing confusion over the meaning of Class 0 and the concept of limited combustibility. LABC was in no way responsible for that confusion, which existed long before it was formed. The confusion was manipulated by unscrupulous players within the construction industry, such as Kingspan and Celotex. Second, the evidence in Module 6 has conclusively demonstrated that successive governments implemented and thereafter maintained a competitive building control regime within a non-prescriptive framework of legislation without sufficient control or oversight. This led to what many refer to as a race to the bottom. Third, LABC acknowledges once again that there were shortcomings in its type approval and registered detail certification for K15 and its registered detail for RS 5000. The evidence conclusively demonstrates that those shortcomings were symptomatic of industry confusion rather than its cause. Fourth, LABC rejects the baseless criticisms that it was corrupt and or dishonest in the manner in which it operated its type approval and registered detail schemes. It emphatically denies the suggestion that decisions it took were financially motivated and or driven by a desire to preserve a commercial relationship with Kingspan and or Celotex. It is denied that these baseless allegations also demonstrate regulatory capture of LABC. Fifth, although LABC issued deficient certificates in relation to both K15 and RS 5000, those errors had been corrected by the time those products were considered for the Grenfell Tower refurbishment. There is absolutely no evidence that LABC certification, deficient or otherwise, influenced the decision to use those products. And sixth, LABC rejects attempts which have been made by other core participants to use LABC as a shield for their own shortcomings. As the inquiry knows, LABC has made radical changes to its company structure and strategic direction. It has already introduced extensive measures to drive up standards in the building control profession. However, it does not regard its work as being done. It has been invited by the panel to participate in the process of identifying potential recommendations arising from the evidence heard in Phase 2. LABC welcomes that recommendation and will actively participate in the process. Point 1, industry confusion. According to Professor Bisbee, the widespread confounding of Class 0 with non-combustible appears to have been a serious problem since at least 1991 and openly discussed with the government since at least 1999. There cannot be, and LABC does not believe there is, any dispute with that proposition. Nor does there appear to be any dispute that successive governments singularly failed to address the confusion despite multiple opportunities to do so, following devastating fires at Knowsley Heights in 1991, Garnet Court in 1999, and at Lakanal House in 2009. In particular, LABC notes what is now the Department for Levelling Up Housing and Communities, and which I'll refer to as the Department, accepts that it failed to keep ADB up to date or to address known ambiguities, including around Class 0. It acknowledges that approved document B was poorly drafted and that it had the potential to cause confusion amongst industry and building control. It accepts it missed numerous opportunities over a period of years, LABC would suggest decades, to identify and understand issues with enforcement and compliance with building regulations. Against such a background of admitted failure by successive governments, it can be no surprise that the confusion which Professor Bisbee highlights persisted or that it manifests itself in LABC certification. LABC takes little comfort from the fact that its deficient certification was a symptom of the widespread confusion and misunderstanding within the industry over the meaning of Class 0 and the distinction between it and materials of limited combustibility. But LABC insists it was not the cause of this confusion and misunderstanding. The industry confusion, coupled with the catalogue of government failures, led to a regulatory regime which was exploitable and exploited by the unscrupulous. LABC realises that it was manipulated by manufacturers who preyed on industry-wide confusion to obtain LABC certification. It naively believed that applicants acted in good faith. But there must at least be a measure of understanding of the point made by Mr. Ewing of LABC when he said to this inquiry, open quote, "I'm still struggling to come to terms with why anybody would actually try and sell a product that wasn't fit for purpose, particularly in relation to fire safety. I am sure he speaks for many." The answer to the question which Mr. Ewing posed, namely, why would anyone do that, is twofold. First, successive governments allow them to do so, and second, the manufacturers' greed. The government had known for many years that manufacturers were selling products which were likely to be unsafe. For example, the moment it became cognizant of the Radar 2 research, which identified that only 4 of the 11 aluminium rain screen products tested, similar to those used on Grenfell Tower, satisfied Class 0 requirements, it should have appreciated that there was something profoundly wrong. This was hard data which proved that the majority of the products tested did not even achieve Class 0. Rather than impose stringent performance criteria on cladding materials, the government preferred not to distort the marketplace or to be a barrier to trade. The department accepts this was, open quotes, another missed opportunity for the department to have reviewed the adequacy of Class 0 and also to have potentially uncovered the manner in which the manufacturers were gaming the testing system, close quotes. It states that it is difficult to understand why the government didn't take action. LABC agrees, and it is grateful to the department for its mostly accurate appraisal of its shortcomings. Point 2, competitive building control. LABC has read with interest the submissions made in particular by the BSRs and the Royal Borough of Kensington-Chelsea relating to the introduction of competition into the building control arena. Mr. Maxwell Scott, Queen's Counsel, on behalf of RBKC, identifies a tension between, on the one hand, the introduction of competition to the building control system by the introduction of approved inspectors, and on the other, the requirement that local authority building control, at least from 2010 onwards, be cost neutral. This was and is the only regulatory regime which was subject to competition. Such a unique arrangement required central government to keep a close eye upon how the system was operating in practice. He contends that a close eye was not kept. LABC agrees. Moreover, the demand that building control bodies be cost neutral placed under-resourced local authority building control teams at a disadvantage to approved inspectors. The expectation that building control bodies would work collaboratively with applicants could compromise their ability to perform their primary function. There was a risk of blurring of lines caused by the expectation that building control bodies would work with an applicant rather than performing a regulatory function. The BSR2 team, led by Mr. Mansfield, observed that the story of NHBC clearly demonstrates that in practice, allowing regulatory services to be carried out by private bodies leads to inevitable conflicts of interest. This chimes with the observation made in a department paper in July 2015, which noted that there was no incentive for approved inspectors to inform local authorities where enforcement action may be needed. To do so would be to bite the hand that feeds them. BSR2 assert with some justification that regulatory functions do not belong in private hands. LABC agrees. Point 3, shortcomings in LABC certification. Briefly and by way of recap, LABC accepts, first, with respect to K15, the type approval summary issued in 2009 should not have stated that K15 could be considered a material of limited combustibility and suitable for use above 18 metres. Mr. Jones of Herefordshire County Council's judgment that K15 could be considered of limited combustibility was incorrect. Errors he made could and should have been identified during LABC's member peer review process. Second, with respect to K15 registered detail issued in August 2013, it wrongly stated that the product can be used on buildings with stories greater than 80 metres from ground level, provided it is used in combination with suitably non-combustible substrates and ancillary components. It was wrong because it could only be used in a system which was identical to that which had been the subject of the actual BS 8414 test. Third, with respect to RS 5000, LABC's first registered system document in 2014 should not have stated that RS 5000 was acceptable for use in buildings with stories above 18 metres in height, subject to the board being fixed to a non-combustible substrate, without explicit reference to the required caveats. Specifically, it could only be used in a system which was identical to that which had been the subject of the BS 8414 test. Having regard to the prevailing industry confusion, LABC contends that its principal failings occurred during two distinct periods. First, in 2009, when the type approval certificate was issued by Herefordshire Council, and subsequently through Mr. Turner's failure to respond appropriately or effectively with the Rockwool complaint. That complaint should have been dealt with more effectively. LABC notes that this was a failing which Mr. Turner shared with the department, who were copied to that complaint and who acknowledged that they too missed an opportunity. Second, from July 2014 to November 2014, when LABC was too slow and insufficiently decisive in the manner in which it dealt with the shortcomings in the RDE for K15, during which time there was a growing appreciation within LABC of the industry confusion. It should now be clear that the original errors made by LABC were a direct result of industry confusion that had permeated the industry for at least 20 years prior to the issue of the first system approval for K15. This confusion, of which government was well aware, eventually resulted in George Lee of the BBA issuing the misleading Agramol certificate for K15, which LABC relied upon when issuing its 2009 system approval and 2013 registered detail. When he gave evidence to this inquiry, Mr. Lee remained under the assumption that Class 0 is equivalent to limited combustibility. Point 4, the baseless criticism of LABC. Although LABC does not wish to detain this inquiry with these submissions, it is necessary to address certain points which appear in the closing statements produced by other court participants. First, the baseless allegation made by BSR1 team that LABC was dishonest in the manner in which it issued the certification. Second, the baseless allegation made by the FBU that the content of the certification was driven by LABC's financial dependency on Kingspan. Dealing first with dishonesty. BSR1 allege that, open quotes, dishonest and unrepresentative testing carried out and certification by BBA and LABC was client-focused and executed by insufficiently competent staff. It is unclear whether that is an allegation of dishonesty levelled at both BBA and LABC or just BBA. Any allegation of dishonesty made against LABC is absolutely refuted. LABC does not accept that there is a scrap of evidence that it deliberately intended readers of its certificates to be misled by them. BSR1's detailed critique of LABC is to be found in section 9 of its written statement. 3 points are made. First, there was a catalogue of errors in the certification from 2009 onwards for K15 and RS 5000. Second, it suggests that there was a flawed certification process. And third, it suggests LABC was, open quotes, played all the way but ready to indulge Kingspan and Celotex. None of these points to LABC's dishonesty. The specific allegation of indulgence is denied. LABC notes that it was never suggested to Mr. Turner or Mr. Union that they were dishonest, and it does not accept either was. However, LABC is not and has never been blind to the unsatisfactory nature of parts of their evidence. By way of example, LABC has readily accepted that Mr. Turner's response to the complaint made by Mr. Cody of Rockwool in 2009 about the literature produced by Kingspan for K15, which indicated that it was a material of limited combustibility, was wholly inadequate. But such a failing falls well short of dishonesty. LABC also accept that Mr Ewing's decision to agree to an extension of the RD certificate for K15 to November 2014 was also wrong. He described it as foolhardy, which it was, given that he knew that a BBA certificate existed and he was aware of concerns which had been raised about the use of K15 by Mr Martin of the department and with Mr Evans of NHBC. BSR state that the admission was warranted. It is clear that the content of the K15 certificate was at that time under active consideration. Mr Ewing was wrong to allow an extension, but that decision was corrected. This clearly demonstrates that he was not dishonest. Financial dependency. The FBU suggests that Mr Turner and Mr Ewing's shortcomings in their handling of the Kingspan matter can only be credibly explained by LABC's financial dependency upon Kingspan. This is a risible suggestion. The income LABC derived from Kingspan was minuscule and could in no way give rise to a dependency. The flimsy basis upon which this allegation has been explored in evidence cannot be overstated. For example, obviously flippant emails and jokes relating to bonuses and saving failing companies between colleagues have been treated as if they were fact. LABC was not beholden to the cladding industry generally or any particular manufacturer or supplier. There was limited financial benefit behind each registration. Neither LABC nor LAB staff were driven by profit and the need to certify applications for financial gain, or to maintain a relationship with any other entity. LABC derived no income from the original 2009 type approval, which included the erroneous statement. Despite this, the allegations of financial dependency persist. Far more credible explanations for the conduct of Mr Turner and or Mr Ewing have been ignored. For example, Mr Turner accepted that between 2008 and 2011 he had frequently engaged and had positive dialogue with Kingspan on matters such as thermal performance, which had become more important to building control, close quotes. It was Kingspan who had become accessible through government-convened groups in which he was partaking. He accepted, with hindsight, that this may have affected how he dealt with concerns about fire performance. He also explained that he had no budgetary responsibility and no responsibility to generate income. Surely a much more credible explanation for Mr Turner's conduct is that he naively trusted Kingspan and thought wrongly they were a responsible organisation. As for Mr Ewing, he was not afraid to make concessions about his and LABC's shortcomings. He accepted the possibility that Kingspan may have been attempting to sweeten LABC with the promise of further registered detail work at a time when there were active concerns about the RD for K15 in 2014. But a proper analysis of the evidence demonstrates that Mr Ewing was not corrupted by the possibility of losing further work. In December 2014, Kingspan made a verbal threat to LABC that it would not proceed with £31,000 worth of registered detail work in relation to other products if the RD for K15 was not extended and or reissued. If LABC was financially dependent in the way that has been alleged, then one would have expected Mr Ewing to do what Kingspan wanted them to do, to extend or reissue the certificate in order to preserve the relationship and secure the work. LABC did nothing of the sort. As Mr Ewing explained, we didn't do anything and didn't jump to the tune. I think this just demonstrates that we weren't that finance driven. The questions you were asking me earlier, this had to be right, and we knew at this point that any registered detail had to be correct when it went out the next time, which wasn't until I think March of 2015. Thus, the evidence clearly demonstrates that the allegation of financial influence by LABC by Kingspan is completely unfounded. Even if Kingspan was attempting to sweeten up LABC, they failed. Mr Ewing accepted that LABC was played all the way by Kingspan and Celotex, but neither he nor LABC indulged either Kingspan or Celotex. The FBU goes even further and suggests that the content of LABC's certificates are a clear example of regulatory capture. The submission is confused insofar as it suggests that the certificates reflect LABC's financial dependence on Kingspan and the like. Tailoring the content of certificates to preserve commercial relationships is corruption, not regulatory capture. This is emphatically denied and without foundation. LABC was played, but it was not corrupt. Point 5. the impact of deficient LABC certificates. LABC has two submissions. First, there is no evidence before the inquiry of any undue significant weight being attached to LABC's certification to demonstrate proof of compliance in accordance with ADB. The inquiry received evidence of an occasion in July 2014 when Mr. Ewing was approached by Mr. Everett of Europa Facades, who indicated that a specialist contractor had sought to rely on the RD for K15 as proof of compliance with ADB and BRE 135. The specialist contractor, singular, he was referring to was Kingspan. This was the only example of such conduct which was ever brought to LABC's attention. It is clear that Mr. Everett did not accept Kingspan's claim at face value, and he gave careful thought to the issue of whether the use of K15 was permissible on that development. In its written submissions, LABC has provided numerous examples from the evidence before you which suggest that LABC itself and LABC's certification were not widely known of or relied upon in the construction industry. Thus, there is limited evidence for the suggestion that the construction industry professionals were relying on LABC K15 certification to justify its use. The evidence before the inquiry of reliance of LAB certification in relation to RS 5000 is, we would submit, non-existent. Secondly, and most importantly, there is no evidence that LABC's historically deficient certificates played any role in the decision to use K15 or RS 5000 as part of the Grenfell Tower refurbishment. LABC addressed these points in detail in its closing submissions to Module 2. Nothing in Module 6 has undermined the force of the points made. Fundamentally, this was because by the time the decisions were taken about insulation on Grenfell Tower, the LABC certificates for K15 and RS 5000 were correct. The historic errors could not and did not make any difference. The only positive evidence of actual reliance was the very late and false claim from Mr. Hoban of RBKC that he had considered an LAB certificate. LABC invites the inquiry to reject his evidence. For examples of the lack of reliance on LAB certification, LABC invites the inquiry to consider Annex B to its closing statement of Module 6. Point 6. LABC should not be used as a shield. It is regrettable that some core participants have sought to use LABC as a shield to justify, defend, or mitigate their own failings. I believe two examples here suffice. First, Kingspan sought to justify its continued marketing of K15 on the basis of an LAB certificate, despite the fact that it knew it was wrong and had been obtained on false premises. LABC need not say anything more about that risible proposition. Second, NHBC has sought to suggest that it was powerless to take action against the use of K15, and it has attempted to blame local authority building control bodies and LABC. It argues that if it had declined to issue final certificates on a development with K15, it would not have made a difference, because the matter would have been referred back to the local authority, who, it asserts, would not have taken enforcement action. Mr. John Lewis of NHBC said this: I think one point which we at NHBC did have in mind at the time was that legally, if NHBC was not prepared to accept the building with K15 on it, then that meant we would not be able to issue a final certificate. And the regulatory process meant that then those schemes would have to revert back to local authority building control for them to take enforcement action. We had in the back of our minds that LABC had a certificate accepting it was a material of limited combustibility, and were generally accepting buildings with this material on it. And so we were kind of thinking, well, is there a great deal of point in rejecting them and sending them back to the local authority if they're likely to still only get approved under the local authority's ways of doing things? LABC does not accept this is true. LABC is unaware of a single example of this happening in practice. This is NHBC's way of abrogating its responsibility for building control. If NHBC, the single largest private sector building control body in the country, had declined to issue a certificate because it was not satisfied that K15 was safe, and it had made clear that this was the basis for its refusal, it is not accepted that LABC's members would disregard that conclusion in the manner NHBC suggest. Concluding remarks. In opening Module 6, counsel to the inquiry indicated that certain court participants were attempting to obfuscate or smuggle something past counsel to the inquiry. Whilst it's not clear which party's CTI was referring to, it is most definitely not LABC. LABC has engaged fully with the inquiry since 2018 in an open and honest manner and has provided full and prompt disclosure. LABC also proactively highlighted where and why mistakes were made. With this in mind, LABC must again categorically refute any allegation that decisions or errors were made based on financial motivation or undue influence. Such allegations, we say, are entirely without merit and not evidence-based. LABC accepts historic mistakes were made, and it was manipulated by manufacturers who preyed on industry-wide confusion to obtain LABC certification. It naively believed the applicants acted in good faith. LABC has monitored the inquiry's proceedings and listened to the evidence presented extremely closely. LABC has acknowledged historic errors and has learned from these errors and addressed competency issues. The steps it has taken included, but are not limited to, the creation of independent, accredited and audited standards framework for local authority building control teams. This quality management system ensures that surveyor competence is matched to project complexity. It has developed Ofqual accredited qualifications for building control professionals, and it's developed a UCAS audited competency validation assessment to measure competence of building control professionals. It has also wound down its registered detail scheme. However, it does not regard its work as being done. It wants to continue to work to regain the public's trust. In that respect, it will actively participate in the process of formulating Phase 2 recommendations, as it has been invited to do so by the panel. That concludes my oral statement on behalf of LABC, and I'd like to thank you for affording me the time to address you.
Well, thank you very much, Mr. Adamson. The next statement is going to be made by Mr. Matthew Butt, Queen's Counsel, on behalf of the National House Building Council. So, Mr. Butt, if you'd like to come up. Thank you. When you're ready, then.
Thank you, sir.
Very much.
NHBC repeats its commitment to assisting this inquiry to ensure that what occurred at Grenfell Tower never happens again. It is crucial that the house building industry learns from the events that took so many lives on the 14th of June 2017. NHBC again expresses its deepest condolences to those who lost loved ones in the Grenfell Tower fire, to the survivors of that fire, and to all those affected by this tragedy. We invite the inquiry to analyse the position of NHBC with the following 6 points in mind. First of all, as a building control body, NHBC operates within a system that at its heart relies upon subjective assessments regarding whether systems such as external wall arrangements will meet the functional requirements of the building regulations. That system is imposed by and can only be strengthened by government. Secondly, NHBC is only one of a large number of organisations offering building control services, and it should not be held to a higher standard than others simply because of its market share. Where NHBC has been criticised for allowing combustible cladding systems to be used above 18 metres, and in particular K15 in reliance upon BBA certificates, NHBC did so based upon third-party assessment of products and materials as outlined in government guidance. The evidence shows that a same or a less stringent approach was taken by other BCBs. What this points to is a wider problem within the industry as opposed to a failing by NHBC. Thirdly, to the extent that NHBC and others have been criticised for working with the building industry, that was what government policy required of BCBs both at the relevant time and today. There have been some suggestions that NHBC's actions in addressing the use of K15 were driven by a desire to hide past errors and/or were commercially motivated, and that some evidence from NHBC witnesses has been an ex post facto rationalisation given to the inquiry. These are serious allegations which require cogent evidence before any such conclusion can be drawn. The evidence is that between 2013 and 2014, it was primarily NHBC staff challenging Kingspan, requesting test evidence, and ultimately driving the industry away from reliance upon certificates, which it is now known were issued in error and based upon deception by manufacturers. Whilst NHBC accepts it should have done more and acted more quickly, the panel will of course examine what other industry groups and BCBs were doing at the relevant time before drawing adverse conclusions against NHBC. Fifthly, NHBC has always recognised that the use of testing or desktop reports was only evidence that could assist in showing whether minimum standards had been met as required. Wherever NHBC considered such reports as a means of showing compliance, NHBC's own fire engineers and their line managers would critically evaluate the reports against the background of their own professional knowledge and experience. Further information would be required from the builder and/or its fire engineer as necessary before NHBC would reach a conclusion as to whether all of the evidence showed that minimum standards have been met. And sixthly, whilst the actions of NHBC and its staff have been carefully scrutinised, it is important not to lose sight of the fact that NHBC was not involved at any stage in the refurbishment of Grenfell Tower. The evidence is one way. Neither the guidance issued by NHBC nor that of the industry group, the Building Control Alliance, was applied, referred to, or contemplated by RBKC or the relevant architects. NHBC has undergone a period of self-reflection since the fire, including in the wake of evidence heard at this inquiry, to consider what it could have done differently during the relevant period. And NHBC accepts the following. First of all, it should not have placed the level of reliance it did upon the Kingspan K15 BBA certificates, given the potential for an error within such certificates. The evidence shows there was over-reliance throughout the industry upon these. The panel might think that a particularly unsatisfactory element of the current regime is that independent certification is capable of showing evidence of compliance with the regulations, but the test evidence behind these certificates is confidential to the manufacturer and not available to builders or BCBs who seek to rely upon that certificate. Instead, the BBA refers builders and BCBs to the manufacturer for any additional or supporting evidence they require. NHBC submits this has created the opportunity for unscrupulous manufacturers to exploit certificates issued in error to an alarming degree. Had the BBA and others known that had there been a system whereby NHBC had been able to obtain the test evidence upon which some BBA certificates were based, this would have exposed Kingspan's misconduct far earlier. Secondly, NHBC accepts it should have acted more swiftly to change its own policy once the problems with Kingspan became apparent. The level of Kingspan's deceit and manipulation that has been exposed in this inquiry is utterly shocking. NHBC was not aware until receiving disclosure in this inquiry as to how far this manufacturer was prepared to go to market its products. It is accepted that one way of tackling the problem could have been for NHBC to refuse to issue building control final certificates where K15 was specified over 18 metres. It is hard to say in 2022 what effect this would have had NHBC taken this stance alone at the time. Other BCBs would have issued building control final certificates, and the possibility of effective enforcement action would have been limited. Nevertheless, it's accepted that unilateral action at that time would have raised awareness of the issue and could have forced swifter and more decisive action. Thirdly, it's accepted that NHBC's 2016 guidance note was insufficiently clear. This is in view of, first of all, the drafting of that document. Secondly, the fact that, unbeknownst to NHBC staff, there was a Class B 100% PE Core ACM panel on the market in 2016. And thirdly, what NHBC now knows about the quality of some Option 3 reports which have been prepared in the industry. The evidence, however, demonstrates that this guidance, which could only apply to NHBC customers, was not in fact used by the builders as a route to demonstrating that any ACM PE cladding facades were compliant. As the inquiry is aware, NHBC is a private company limited by guarantee. It has no shareholders and is non-profit distributing. Any revenue above operating costs is reinvested in the organisation to fund its purpose and ensure sufficient capital is in place to back its insurance business. NHBC provides building control services through its subsidiary, NHBC BCS, as an improved inspector. NHBC is not the house building industry's regulator. Whilst NHBC BCS must apply and interpret building regulations and make judgments as to whether these have been complied with, which NHBC staff confirm they do fearlessly, independently, and without regard to commercial considerations, this does not make NHBC a regulator in a technical or legal sense. NHB's reputation, built over more than 80 years, is grounded in public, industry, and customer confidence in the safety of the buildings that it's involved with for both warranty and building control services. Upholding standards is a key part of ensuring that reputation is maintained. Each NHBC witness was questioned about their expertise and qualifications, and it submitted that those in key positions at NHBC were suitably qualified and experienced to perform the roles required of them. At the time of the fire in 2017, between Mr. Evans, Mr. Lewis, and Ms. Marshall, there was a combined total of nearly 100 years working in the building control industry. Mr. Evans has a degree in building surveying, and since he began working as a building surveyor in 1991, he had been involved in buildings ranging from small houses to airport terminals and football stadiums. Ms. Marshall holds a first-class degree in building engineering and is a past president of the Chartered Association of Building Engineers. Mr. Lewis holds a BSc in construction management and an MSc in fire and explosion engineering. He has been a building surveyor since 1994 and from 2013 was a specialist fire engineer. Other external and internal fire engineers were employed where necessary. This meant that for the key period in question, from 2013 onwards, NHBC had either internal and/or external fire engineering advice available, and its approach was always to take specialist external advice where required. To the extent that it's been suggested to NHBC witnesses that they or NHBC's actions in dealing with Kingspan were motivated either by a desire to cover up past mistakes or to increase market share for commercial advantage, this is strongly refuted and is inconsistent with a fair reading of the evidence. NHBC would ask the panel to consider the following four matters in this regard. First of all, raising standards in the industry and improving the quality of housing is why NHBC exists. Any profits that are made are reinvested for that purpose. Brian Martin said that NHBC was more than just a commercial enterprise and had taken positive steps in dealing with combustible cladding problems. The suggestion that standards were lowered for profit was strongly refuted by all NHBC witnesses. As Mr. Evans said in evidence when it was put to him that it would have been bad for business had NHBC stopped accepting the use of K15 over 18 metres. It was not done to protect market share. It was not done for any other reason than to allow industry to give us the information so we could make an informed decision, which we did in 2015. I'm a building control professional. I've been in the industry 32 years. At no time was any approach made to me to find a solution to protect NHBC's integrity or historic buildings. If anyone had, I would not be working for that employer. And this typified the reaction of all NHBC staff when such suggestions were put to them. There is no evidence that could reasonably and safely lead to a conclusion that NHBC's actions were in some way designed to cover up past mistakes. NHBC has disclosed all relevant communications and documents from key personnel over an extensive period. No document has been identified which supports any positive theory that evidence now given is a recent invention, far less that NHBC was acting out of a desire to secure a commercial advantage. The evidence shows clear and candid concern on the part of NHBC about, in particular, the actions of Kingspan and a determination to get to the bottom of whether K15 was safe for use above 18 metres, and if so, in what circumstances. As to being driven by profits, it was the evidence of Steve Evans that the letter sent to NHBC's customers in March 2015 informing them of the change in NHBC procedure to require compliance with the BCA guidance note, caused difficulties with NHBC customers and led to projects being rejected and negative commercial consequences for NHBC. One example of this is the Apex project, a warranty proposal where a desktop report was provided by the builder supporting the use of ACM PE cladding. NHBC refused to provide a warranty for this building as its own internal procedures suggested that the cladding makeup was not compliant. This refusal was made notwithstanding the very full evidence provided from Dr. Raymond Connolly, who provided further updated reports insisting that the cladding was compliant with the regulations and presented an acceptable risk. NHBC was also aware that this project had received a final certificate from the relevant local authority who provided building control for the project. Following this refusal, a different warranty provider was content to offer a warranty and took a fee for doing so, notwithstanding the presence of 100% PE ACM cladding in the facade. John Lewis also gave evidence that NHBC's customers were complaining that NHBC was requiring more than their interpretation of ADB required, which is supported by contemporaneous correspondence. CTI has also established from each of NHBC's witnesses that NHBC interpreted ADB as requiring compliance with both paragraphs 12.7 and diagram 40 of ADB, thus requiring that all elements of the cladding makeup, including filler materials, were materials of limited combustibility. As the inquiry has established, this was far from the universal approach adopted across the industry, with some designers, manufacturers, and builders considering only the combustibility of the outer face and not its core. Had NHBC been attempting to lower standards for commercial advantage, then it could have chosen to interpret ADB as requiring compliance with either paragraph 12.7 or diagram 40, which would have enabled combustible materials to be used in a wider variety of makeups without desktop reports. It is untenable to suggest that these were the actions of an organisation seeking to lower standards for commercial advantage. This inquiry has confirmed that the building regulation regime before the Grenfell fire was complex and non-prescriptive with a deficit of clear guidance. The extensive reform of fire safety and building safety regulation and guidance following the fire at Grenfell Tower amply demonstrates the pressing need for reform which existed in 2017. One of Dame Judith Hackett's key findings was that the package of regulations and guidance in the form of approved documents can be ambiguous and inconsistent. NHBC and the industry as a whole had to work within that imperfect framework. It is the builder's sole responsibility under the regulations to ensure works comply with those regulations. A BCB cannot provide a guarantee of compliance with the regulations, and the process does not remove the obligation of the person carrying out the work to achieve compliance. An AI also cannot insist on a higher standard than that set out in the building regulations. There has long been confusion over the application of ADB, so much so that the coroner in the Lacanau inquest, Her Honour Judge Francis Kirkham, CBE, made recommendations in 2013 to government in which she concluded that ADB is the most difficult document to use. Her recommendations included the clear guidance in relation to Regulation B4, with particular regard to the spread of fire over the external envelope of the building, was provided and expressed in words intelligible to the wide range of people engaged in construction, maintenance and refurbishment of buildings. The Secretary of State responded as set out at paragraph 43 of our written submissions, assuring the coroner that the department was committed to a process of simplification and that research was commissioned which would feed into a review of ADB and a new edition in 2016-17 to ensure the guidance was capable of being more easily understood. The reality, however, was that the recommendations within the Lacanau House report were not acted upon before 2017, and instead government relied upon the industry to issue guidance in the interim. Industry guidance obviously does not have the same status as statutory or government guidance. Nevertheless, MHCLG's approach was to rely on industry guidance to fill at least a temporary gap where interpretation was required, because it did not have, according to Brian Martin, a mechanism for changing the approved documents very quickly. So we tried to get industry guidance to resolve problems that might have arisen in between reviews. The evidence was that had industry not sought to adopt a consistent application of the building regulations through guidance, there would have been what Brian Martin described as a really big problem, bigger than the one we're dealing with now. NHBC submits that the house building industry should not have been placed in this position, and the panel should be slow to criticise those who use their best efforts to ensure consistency and drive improved standards in the industry whilst working within an imperfect system. The use of combustible materials in construction is not new. MHCLG was aware of the issues concerning external cladding systems throughout the review of ADB, which led to the 2006 edition being published. It was suggested to NHBC witnesses that reliance upon the BBA certificate was an ex post facto justification for NHBC accepting K15. This is strongly refuted. Reliance on an independent certificate as evidence of compliance is and was wholly permissible, as confirmed by several authorities set out in paragraph 46 of our written submission. The use of BBA certificates has long been a part of industry-wide building control processes in the UK and remains so today. NHBC, of course, accepts that in its role as an AI, it's concerned with whether there is compliance with a specific or functional requirement of the building regulations, and is required to take reasonable steps to satisfy itself within the limits of skill and care. In doing so, BBA certificates may be relied upon by a BCB. NHBC knew the BBA to be an accredited and trusted organisation and had no reason to doubt its competence. The actions of NHBC in respect of the various BBA certificates relating to, in particular, K15, do not, however, show that it blindly relied upon those certificates. If that had been the case, NHBC would not have needed to have undertaken its own extensive investigations into K15. The BBA certificate for K15 had been in use and accepted by other BCBs since 2008. Prior to 2013, no concerns had been raised in the industry or by government about it. Mr. Evans told Mr. Martin in July 2014 that on the basis of the BBA certificate of 2008, NHBC and other BCBs had accepted the use of K15. This did not cause Mr. Martin to contact Mr. Evans and raise concerns over this. It is beyond dispute that other BCBs accepted the BBA certificate at face value and that this was standard practice within the industry. It was Mr. Evans' evidence that other BCBs interpreted paragraph 7.3 of the certificate in the same way as NHBC, that it allowed for K15 to be used over 18 metres, either based on the certificate alone or by reference to the manufacturer. This was confirmed in the Philip Pettinger email of the 3rd of April 2014, in which he stated that on warranty-only jobs, NHBC are accepting K15 if the building control body is happy and deem it to comply. They always are and always do. Mr. Turner of LABC, who had previously worked for a local authority providing building control, said that whenever in my role within a local authority, when anybody came to me with a product that I'd never heard of or not seen before, my question was, does it have a BBA certificate? Does it meet the requirements laid down? Indeed, as the panel is aware and has just heard, LABC went further and issued its own registered details certificate for K15. This was issued on the basis that K15 had the appropriate BBA certificate. LABC's position remained supportive of K15's use, even when concerns were raised with LABC by another manufacturer. There were also real problems with the BCB suddenly taking a unilateral stance to refuse to accept the certificate. As Mr. Evans explained to the inquiry, had NHBC refused to accept K15, its only real power as an AI would have been to refuse to issue a final certificate so that development would revert back to the local authority for enforcement action. Mr. Lewis said that NHBC knew that given a local authority BCB would regard the use of K15 as compliant, given the existence of the BBA certificate and or the LABC registered detail, they were consequently unlikely to take enforcement action. It is unclear how a local authority could both accept K15 in its role as a BCB, but then also take enforcement action against a builder when they had used it, regardless of the position of the AI who had acted for building control. NHBC's refusal would not have stopped the use of K15 and was likely to have created more confusion in the industry. Mr. Evans was asked to explain why he allowed NHBC surveyors to permit the use of K15, having seen the amended BBA certificate dated the 6th of April 2010, but published in 2013 with retrospective effect, which suggested K15 could be used in accordance with paragraph 12.7. First, as Mr. Evans explained, NHBC had questions at the time that it wished to explore when faced with this certificate produced by a reputable accredited body. As Mr. Evans said, in our mind, there had to be a reason why BBA were making that statement. Kingspan must have provided them with information at that time in order to make that statement. What we wanted to understand was, what information had they provided? What information had they got which we hadn't, which allowed them to make that statement? Whilst it's of course accepted that Kingspan would not be able to show that K15 was a mulk, it was not unreasonable to think that having apparently passed one test, Kingspan would be able to provide, as repeatedly promised, further tests which would demonstrate K15's reliability in a variety of wall makeups. After the reissue of the certificate on the 17th of December 2013, NHBC knew the complex buildings being designed would not have concluded their construction stage for quite some time. So there was time for NHBC to complete its investigation when Kingspan was repeatedly assuring it that it could provide further information to demonstrate compliance with the building regulations. As the BBA would not provide the information used in its assessment, NHBC took the only available route it had and raised its concerns and requests for evidence directly with Kingspan. Brian Martin's evidence was that in this difficult situation, I thought NHBC waiting for more tests to come back was the best available answer we had. NHBC was not permitting Kingspan to mark its own homework. What it was doing was investigating the evidence to support Kingspan's claims. The fact that Kingspan prevaricated and lied to NHBC significantly contributed to the length of the process. There was a suggestion in questioning of NHBC's witnesses that it could have sought information from the BBA. The reality is the BBA would not have provided such information to NHBC on the basis of its confidentiality agreement with Kingspan and would have referred NHBC to Kingspan, with whom it was already in dialogue. NHBC refutes any suggestion that it took a lax approach to fire safety. The evidence is that NHBC was regarded as difficult by the building industry, particularly in relation to building control, and that this harmed its commercial relationships. Contrary to any suggestion that NHBC was in league with Kingspan, Brian Martin said in evidence that NHBC was taking leadership over dealing with Kingspan, and that he saw NHBC doing this both as a positive thing and reflecting the way the government encouraged industry to behave. NHBC's efforts to confront Kingspan are evidenced by the volume of correspondence seen by this inquiry, which shows NHBC staff challenging Kingspan and pressing it for test data, absent which builder customers would have been informed that the product would not be accepted. For example, on the 16th of June 2014, Mr. Evans wrote to Kingspan explaining that unless it provided additional test evidence, NHBC would need to consider whether it would accept K15 in buildings over 18 metres as fit for purpose. Further, on the 10th of October 2014, at a meeting with Kingspan, NHBC explained that unless it received a letter of comfort from BRE and ARAP, it would start to inform its builder customers that K15 was no longer acceptable in buildings over 18 metres. This was followed up by email, where NHBC emphasised the need for Kingspan to move quickly, and the letter to Kingspan dated the 5th of February 2015, in which NHBC set out the action it was taking and additional requirements that K15 would now be subject to. These were then communicated to all NHBC builder customers. Kingspan was sufficiently concerned by NHBC's actions that they went as far as to instruct lawyers to threaten NHBC with an injunction, which did not change NHBC's decision to change its policy. When considering the degree to which it's fair to be critical of NHBC for its approach, the panel might ask what evidence there is of other BCBs, including local authorities, taking similar steps during the relevant period. Whilst NHBC did more than others in the industry, it accepts that it was not enough. In terms of BCA guidance, Mr. Evans explained that one of the reasons for the formation of the BCA was because, as a profession, BCBs didn't want to compete on technical standards, and as builders shouldn't be shopping around for lower standards. The panel must, of course, be careful to differentiate between NHBC and the BCA. The two organisations are separate and perform different functions from one another. The BCA members are represented on its committees by professionals working within the building control industry, with the expertise to contribute and review proposed guidance independently. In putting their names to the guidance under the BCA umbrella, each member, including LABC, had an obligation to its own organisation to ensure that it reviewed and agreed with the terms of that guidance. Draft guidance was also provided to MHCLG as a papers-only member of the BCA. Aside from receiving relevant documents, MHCLG could and would occasionally attend meetings. In relation to the BCA guidance note, Mr. Martin said this was a short-term solution to the problem. We've addressed both options 3 and 4 in our written closing. Giving time constraints, I will confine these oral submissions briefly to option 3. It is unsustainable to suggest that desktop assessments were a creation either by NHBC or the BCA, or that they were created to legitimise alleged past practice. They were an established convention. NHBC had seen desktop reports for other elements of construction, such as fire doors and cavity barriers. Steve Evans confirmed that these reports were part of our daily work. The use of desktop reports for external wall systems was first raised not by NHBC or by the BCA, but at a meeting with and by Wintec in November 2013, as documented in NHBC's note at the meeting and the evidence of Stuart Taylor of Wintec, such a report having been provided to Wintec by the BRE. Further, at no time did MHCLG raise any concerns or suggest that option 3 was not compliant with ADB. In an email to Mr. Evans on the 21st of June 2016, Mr. Martin said, "I'm comfortable with the principles set out in the BCA guidance note. The 4 options are a matter of fact." Mr. Martin's evidence was clear that the BCA guidance note was a good thing, and that he said it was more restricted than at least some interpretations of ADB. He also said it made ADB safer. Where option 3 desktop assessments were provided to NHBC, these would be scrutinised, challenged, and further evidence required, where necessary, before NHBC would issue a final certificate for building control purposes. The process was that a fire engineer would review each option 3 assessment, and it would then be escalated to Steve Evans for a further review, who would send it for formal internal sign-off by a senior manager, usually Diane Marshall or Ian Davis. Whilst not qualified fire engineers, Ms. Marshall and Mr. Evans are long-standing professionals who are familiar with the requirements of the regulations. Had there been any desire to lower standards, NHBC would not have been put in place a multi-layered approvals process. It is correct that Mr. Martin discussed with NHBC concerns about some desktop reports, but he clarified these were not for NHBC projects. Mr. Martin said he was happy with how Mr. Evans, speaking on behalf of the BCA, addressed the issue during his presentation at the Facades to Tall Buildings conference in July 2016, and said he hoped this would improve the industry's understanding and provide clarity until the issue could be addressed by way of a review of ADB. NHBC witnesses have been closely questioned on the motive behind publication of Technical Guidance Note 18, and if this was an attempt to make compliance easier. It's important to repeat that it was the BCA and not NHBC that published the BCA Guidance Note. The panel will also appreciate the point that if it was truly NHBC's motive to increase its own profits by winning more work for itself by allowing option 3 reports, it would have issued the guidance in its own name and not work with other bodies around the BCA table to produce, review, and issue the BCA guidance. The 2014 note was amended in June 2015 to allow option 3 desktop assessments to be undertaken by any suitably qualified fire specialist. As with all previous BCA guidance, this was agreed by all BCA members in the technical committee. Neither MHCLG nor any members of the technical group raised the possibility that the term fire specialist might be misunderstood and or lead to less qualified people undertaking the assessment. As far as NHBC was concerned, any review by it of a desktop assessment would have picked up any deficiencies, including the expertise of the author. There is no evidence the change in language in fact led to a dilution in standards. As the inquiry is aware, fire engineer is not a protected title. The only way for that problem to be remedied is for regulation of this field of work, which is something NHBC would welcome. It was suggested to John Lewis that BRE Trust BR135 guidance, if read side by side with ADB, would suggest that option 3 was not a valid form of compliance, and as there was no means of extrapolating test data from BS 8414 tests. The evidence is that this could not preclude option 3 from being a possible route to compliance, not least of all as ADB sets out possible as opposed to exhaustive or prescriptive routes. Paragraph 0.21 expressly states that there may be alternative ways of achieving compliance with the building regulations than provided in the guidance. If it were the intention of government to exclude an otherwise standard route to compliance, then this would be explicit. To the contrary, the effect of Appendix A is to allow desktop assessments. This was Brian Martin's understanding of the wording of BR135, as explained to the inquiry. As to the refurbishment of Grenfell Tower, RBKC did not refer to the BCA guidance during its work on Grenfell Tower. It had no impact on the project. In terms of NHBC guidance, the purpose of NHBC's external guidance was to set out in a transparent manner that if the NHBC builder customer could show it had followed that guidance, NHBC Building Control Services was likely to accept that project in question for building control purposes. That was not, however, a foregone conclusion, because NHBC would always check each project on a case-by-case basis. As explained in evidence, the 2016 NHBC guidance note was based upon NHBC's experience of reviewing option 3 and option 4 reports. There is simply no evidence that it resulted from lobbying by Kingspan or any other manufacturer. The guidance note was launched at the July 2016 conference where Brian Martin was present, and whose view was that this was, in principle, a permissible approach and did not widen the routes to compliance within ADB. NHBC has accepted there were shortcomings with the document, and when asked by CTI, Mr. Evans said he did not stand by the 2016 NHBC guidance note based upon the post-fire MHCLG testing. Importantly, this guidance note was not in the event used to accept any buildings with ACM cladding. Steve Evans said that NHBC checked all builds which had used the 2016 note, and no buildings with ACM cladding had used the guidance as a means of showing compliance. After the fire, NHBC reviewed all its relevant guidance to reflect the withdrawal of the 2016 guidance note. This resulted in NHBC issuing new internal guidance in August 2017, then updated in December 2018. The 2016 guidance note could not have been used when considering whether the cladding on Grenfell Tower was compliant. Other BCBs should not have used NHBC guidance to complete their own work, and the evidence is that RBKC did not do so. In fact, the publication date was after John Hoban issued a final certificate for the refurbishment work. John Lewis said, in evidence, that if Grenfell Tower had been an NHBC project, it would have been referred to him and he would not have accepted it. Finally, reviews. As has been well established, NHBC conducted various reviews into projects where it provided either building control services or warranty insurance that are relevant to combustible cladding. The 2015 combustible cladding review looked at schemes that were registered from the 1st of January 2014 and projects still in build registered prior to that date. This review required that for all projects which had commenced pre-2014, there was confirmation from Kingspan that K15 was suitable for use over 18 metres on that project. For all projects where the notice was issued in 2014 or 2015, NHBC ensured that one of the routes in the BCA guidance note had been followed, which included checking the internal escalation procedure, which I've already explained. None of the buildings in the 2015 review had specified the use of ACM cladding with a PE core. The 2017 post-fire review looked initially at projects that had been accepted under the 2016 NHBC guidance note as the basis for compliance. A small number of buildings were identified which specified ACM cladding. However, none of these had used the 2016 guidance note as a route to show compliance, and none had a PE core. The buildings specifying ACM were then investigated under the terms of NHBC's internal guidance, B600, which took account of new MHC-LG test evidence. Once this process had been completed, it was extended to a review of all projects under construction to ensure that wherever option 3 or 4 had been used as a route to compliance, they met the required standard. These too were checked under the revised procedure under B600. CTI has pressed NHBC witnesses as to why the reviews did not cover historical projects where NHBC had provided building control services, as the high market share enjoyed by K15 would suggest a large number of projects would have been completed with this product. There are 3 matters we asked the panel to consider in this regard. The first is, an AI has no power to impose conditions or prescribe modifications to completed works. The powers of an AI are limited and cease completely after a final certificate has been issued. Secondly, in relation to buildings constructed between 2008 and 2014, where K15 had been specified, NHBC would have issued a final certificate, assuming all other matters were compliant, if K15 had been used in accordance with the BBA certificate, including reference having been made by the builder to Kingspan as the manufacturer. Once that had been issued, NHBC would have no power to contact the builder and require or request the cladding used be checked. Thirdly, this must take into account what has happened since 2017. There has, of course, been extensive publicity about K15 and combustible cladding generally since the tragic fire at Grenfell. This has led to inquiries with builders and warranty providers in order to establish whether the cladding that has been used was compliant. As a result, central and local government conducted its own review into properties which might have combustible cladding. As the panel is aware, after the Grenfell fire, a letter was sent to all local authorities asking them to assess all buildings over 18 metres within their region in order to assess risk from ACM cladding. And NHB, of course, has cooperated with that process. So, in conclusion, NHBC reiterates its commitment to assist in the inquiry to ensure that what occurred at Grenfell Tower never happens again. We wish to reiterate that at all times NHBC acted with its core purpose to improve standards in house building, often going further than other BCBs or industry bodies, and that this came before any commercial considerations. And finally, NHBC is keen to learn any lesson it can and to play its full part in ensuring an improved fire system in the UK house building industry for the future. So those are my submissions.
Well, thank you very much, Mr. Butt. We are running a little bit ahead of time, but I think that's a good point at which to take our afternoon break. And when we come back, we'll hear a final statement from DAUHC, which is going to be delivered by Mr. Beer, Queen's Counsel. We'll rise now. We'll come back at 3:25, and then we'll hear Mr. Beer. Thank you very much. 3:25, please. And now finally this afternoon we're going to hear a closing statement from, on behalf of the Department for Levelling Up Housing and Communities, made by Mr. Jason Beer, Queen's Counsel. Thank you very much.
Thank you very much, sir. I'll again refer to the department as the department.
Yes.
And as it has done throughout the inquiry, the department has assisted and supported Module 6 by providing, by way of disclosure, thousands of documents to the inquiry, by providing 26 witness statements to the inquiry from 19 witnesses, ranging from the then Secretary of State to former ministers, to the then Permanent Secretary, other senior civil servants, and very junior civil servants, from which number the inquiry heard oral evidence from 10 departmental witnesses. And finally, by setting out in its 45-page written opening statement its position in relation to the issues that arise in Part 2 of Module 6 of the inquiry, namely the adequacy or otherwise of the building regulations and approved documents, as well as the amendments to them, the adequacy or otherwise of other standards and guidance, including in relation to fire safety measures, the fitness for purpose of the testing, certification and classification regime for exterior wall materials, and the adequacy or otherwise of the department's response to recommendations from various sources in the years leading up to the fire on the 14th of June 2017. As the department set out in its written opening, it accepts responsibility for the failures of the past, and in particular its failure to understand how and whether the regulatory system was working in practice or how it was being enforced. In this regard, the department failed to exercise sufficient oversight of a system that it owned as the sponsoring government department. Furthermore, the department accepts that it should have put in place a system that enabled officials within the department to take on board, to work on, and then to progress the lessons learned and recommendations given following other fires, including those tragic events at Lakanal House in July 2009. Whilst the department's recognition of these failures cannot change the terrible events of the 14th of July 2017, nor atone for the immeasurable loss and grief suffered by the bereaved survivors and residents, the department hopes that its sincere commitment to learning the lessons of this tragedy will give a measure of solace to those affected. The issues that arose for the inquiry in Module 6, Phase 2 can be summarised in the following way. Up until June 2017, what was the system in place for the testing, certification and classification of exterior wall products? Up until June 2017, what was the legislative system in place in England and Wales in respect of building regulations, and what role did the department play in it? How did the regulatory system develop, and was it adequate? What recommendations were made, and from what sources, as relevant to the risk of fire at Grenfell on the 14th of June 2017, bearing in mind its composition and occupancy? And what steps did the department take to address such recommendations? Were those steps appropriate as related to the risk of fire in high-rise residential buildings? The extent to which any inadequacies in the building regulations, approved documents, standards or other guidance, or to what extent any failure to act upon warnings or recommendations as to the risk of fire spread in high-rise residential buildings caused or contributed to the manner and speed of the spread of fire at Grenfell Tower, the extent of the damage and the number of casualties is ultimately a matter for the inquiry. Turning briefly then to the testing, certification and classification of exterior wall products. This is an area in which the department has historically had less involvement, and I will therefore leave it to other better placed core participants to outline the relevant structure for the inquiry. However, notwithstanding the extent of the department's historical involvement, it has listened carefully to the evidence throughout the inquiry and notes that this evidence has established that the system of testing and certification was being gamed by certain manufacturers. The department has already introduced the Building Safety Act 2022, paving the way for a new national regulator for construction products. covering all construction products marketed in the UK with powers to withdraw products from the market if they present a safety risk. In addition, this will no doubt be one of the issues considered by the independent review of the effectiveness of the system that the Department has already established in line with the findings of Dame Judith Hackett. To the extent that the inquiry is considering within Module 7 the adequacy or otherwise of small-scale tests as a means of classifying exterior wall products, and the issue of desktop assessments as a means for certifying such systems, the Department looks forward to any recommendations from that evidence. However, the Department's preliminary view is that both retain some benefit as methods of classifying products and demonstrating compliance. And in this regard, I would highlight the point made in the written closing submissions of this module by others, namely that tests, and particularly small-scale tests, should not be relied on in a vacuum. A competent designer should also consider how those components are to be used within a whole system. And that issue of the competent designer is one to which I will return later. So the system of building regulations and the Department's role in it. The Department set out in some detail in its written opening for Module 6 the genesis and development of the regulatory system of the building regulations, and I will therefore not repeat that here. However, the essential features of it, noting that some of them have now changed through the Building Safety Act, and which are relevant to the issues that I'm going to address, are as follows. First, the system enshrined at the time in legislation by the Building Act 1984 and the various building regulations made thereunder was and continues to be an outcomes-based regulatory model which provided flexibility in an era of complex, infinitely varied and evolving systems of construction. The Secretary of State has responsibility for the overall system, and the Department is the sponsoring department. Approved documents are produced under the provisions of the 1984 Act and are approved by the Secretary of State to provide guidance for those involved in the construction industry for common building situations. There was and still is no legal requirement to follow the guidance provided in an approved document. Whilst the approved documents cover a range of topics, approved document B obviously concerned fire safety. The fire protection of buildings, including their design, is a complex subject, and therefore, whilst approved document B is intended to provide guidance for common situations, such guidance is necessarily for the benefit of competent professionals. That is something which is recognised by others in their written closing submissions, where it is suggested that it is, quote, obvious from a perusal of paragraphs 12.5 to 12.9 of approved document B that compliance with the linear route is an issue that should have required expert advice and input. On behalf of the Department, I would respectfully agree. The system was a decentralised one, and once the Secretary of State had set the standards in the form of the building regulations, and if he or she chose to do so, given guidance by way of the approved documents, it was then for local authorities to monitor and enforce compliance. The Department did not at that time have any superintending role within the building regulations to ensure that local authorities were carrying out their role properly. Both local authority building control bodies and approved inspectors can provide certification that works have been carried out in accordance with the building regulations. The Department played no role in that. Ultimately, it is for the person carrying out the building works, whether themselves or through their contractors, to comply with the provisions of the building regulations. I would invite the inquiry to keep those propositions as to the system in place at the time in mind when considering the evidence given by the Department and other witnesses during the course of the Module 6 hearings. So the development of the building regulations and approved document B. This inquiry has heard a great deal of evidence detailing the changes to the building regulations and the approved documents, spanning a period of 32 years from the building regulations 1985 to the date of the fire. In respect of the building regulations themselves, whilst there was a period in which functional requirement B4 was arguably stronger, at least semantically, because the word adequately was omitted, I would note the conclusion respectfully that the inquiry drew in its Phase 1 report, namely, quote, although in another context there might be room for argument about the precise scope of the word adequately, it inevitably contemplates that the exterior must resist the spread of fire to some significant degree appropriate to the height, use and position of the building. The department respectfully submits that that is exactly the conclusion that should be drawn when the inquiry is considering functional requirement B4, and that it must follow that the inclusion or exclusion of the word adequately does not materially affect the suitability of this drafting. A competent professional would or should have understood that functional requirement B4 inevitably contemplated that the exterior wall of a high-rise building must resist the spread of fire to some significant degree. Turning to the approved document, the department accepts that the inquiry has identified aspects of the drafting in various versions of ADB that were potentially confusing to industry and to building control. Much of the inquiry's evidence on the issues identified within approved document B focused on the 2006 edition and the amendment of the title to paragraph 12.7 to, quote, insulation materials stroke products, and the introduction of the word filler. Whilst the department accepts, as did Mr. Martin during his evidence, that both of these amendments were capable of causing confusion, the department would reiterate that a competent professional faced with the decision as to whether to use, for example, an ACM PE panel should have, in the face of any ambiguity in approved document B, been referring themselves back to the functional requirement and considering whether specifying a product, such a product, would meet the overall objective of ensuring that the exterior wall in question resisted the spread of fire to some significant degree. The department would suggest that it is plain that the professionals engaged in the refurbishment of Grenfell Tower and those professionals engaged in the construction and refurbishment of other high-rise residential blocks in the country cannot claim to have seriously turned their minds to the question of compliance with functional requirement B4 in any meaningful way. Furthermore, the preponderance of high-rise buildings clad with ACM PE panels and combustible insulation demonstrates that local authority building control and approved inspectors were not applying their minds, or not competently applying their minds, to the basic functional requirement. But this position is supported by the BRE's written closing submissions for this module, and indeed by Professor Bisbee's report, Phase 2 Regulatory Testing and the Path to Grenfell, at paragraphs 929 and 930. To the extent that it has been suggested by some core participants that the department's interpretation of filler as including the core of an ACM PE panel is an ex post facto rationalisation, or that it represents a political lie, this must be viewed against the unequivocal evidence of the BRE's witnesses that approved document B in 2006 prohibited the use of ACM PE panels. There has been no collusion between the department and other parties in asserting that the term filler was intended to cover the core of such panels. The simple truth is that cores were one of the things, to use Mr. Martin's term, that the word filler was intended to cover. It was the department's belief throughout the period in question that if a competent professional applied the provisions of paragraph 12.7 of approved document B correctly, it prohibited the use of ACM PE panels because of the presence of the highly combustible core. To the extent that it has been argued by Arconic that the wide use of ACM PE panels demonstrates that they were treated as acceptable by government, I would invite the inquiry to consider that the department's role was a decentralised one, and it did not hold any sort of database about what products were being specified and where. This is supported again by the written closings of the BRE, which reinforce the department's position that generally compliance with the building regulations and guidance was thought to be being achieved, and that until relatively recently, before the 14th of July 2017, the department was not aware that ACM PE panels and insulation were being widely used in practice. Certain core participants have suggested that the department adopted a head-in-the-sand approach rather than facing up to the predictable legacy of buildings clad with ACM PE panels. For the reasons that I've just explained, this is not the case. Properly considered and applied by a competent professional, functional requirement B4 would not permit the use of such materials, and ADB 2006 was always intended to effectively prohibit the specification of composite materials with combustible cores. The department, in its decentralised role, with a lack of any superintending function, did not appreciate such materials were being widely specified in practice until much later. Turning to relevant recommendations and the department's response. The department has set out in its closing submissions for Module 6 a chronological list of its responses to historical recommendations, and it accepts that it failed to take heed of the various warnings given over a number of years that might have enabled it to identify the widespread compliance with the building regulations that the inquiry has uncovered. Because the inquiry has our written closing, I do not propose to rehearse each occasion on which the department accepts that it missed an opportunity to reflect on whether the building regulation system was operating as intended. But I would wish to take this opportunity to respond to one discrete point made by some of the bereaved survivors and residents in their written closing submissions for this module, and to reinforce the reasons why the department considers that those recommendations and warnings were not heeded in the way that the bereaved survivors and residents might have expected them to have been. Dealing first with a point made in BSR Team 1's closing submissions. It's asserted that the inquiry should draw conclusions from a document suggesting that the Knowsley Heights fire be, quote, downplayed or played down. The simple point I would wish to make in response to this is that the inquiry hasn't heard any evidence, any oral evidence, from any witness who can speak to what the intention of that suggestion was, what lay behind it, but what it meant. And therefore the inquiry should, in our submission, be slow to draw any conclusions in respect of it. As to the reasons why the department missed the opportunities presented to inquire into the effective operation of the system, the department would suggest respectfully that they're fourfold. Firstly, the lack of a formal oversight role for the department in the regulatory framework. Secondly, and connected to that, a reliance on industry. Thirdly, financial constraints in the department. And fourthly, the deregulatory policy. The department would suggest that these elements combined led to a situation where officials felt unable to escalate concerns when they arose. It's apparent from the submissions made by other core participants that it is appreciated that financial constraints are accepted to have had an impact on the department's operations. It's of particular note that others recognise that whilst Mr. Martin himself asserted that he was a single point of failure, in reality, responsibility was not one that could possibly fall on one person's shoulders. In respect of deregulation, whilst the department would not accept that the delays to the publication of the 7 work streams was due to it being, quote, enslaved to the deregulatory agenda despite safety warnings, as has been suggested by others. The delays, I would suggest, are primarily demonstrative of an underappreciation of the risks by the department in not updating approved document B sooner, based upon a false understanding that the system was generally operating as it should be. But the department would accept that deregulation played a part in underpinning a culture in the department where officials felt unable properly to escalate warnings when they were raised, or to progress work in response to recommendations, and in particular those made by the coroner following the Lacknell House fire. The department would accept that an exemption from the building regulations or at least those aspects of them which concerned life safety, should have been sought from the deregulatory agenda. Although to the extent that it's suggested by the FBU that Dame Melanie herself should have known about the lack of such an exemption, apparently drawing, the FBU do, a direct line between her time as Permanent Secretary and Lord Pickle's time as Permanent Secretary, I would respectfully remind the inquiry that Dame Melanie was only in post as Permanent Secretary during Lord Pickle's tenure for 10.5 weeks. The department regrets that such a culture was allowed to form and has overhauled its risk management procedures in the years following the fire to ensure that in future risks are properly flagged and are escalated. The department remains committed to learning from the tragedy and to taking steps to ensure that such a fire cannot happen again in England and Wales. The Fire Safety Act 2021 and the Building Safety Act 2022 will bring about improvements in building safety, the biggest improvements in building safety for a generation. The latter act paves the way for the establishment of the Building Safety Regulator under the umbrella of the Health and Safety Executive and a new national regulator for construction products as part of the Office for Product Safety and Standards. In addition, the department has committed to invest £5.1 billion to address the fire safety risks caused by unsafe cladding, of which £1.7 billion has already been allocated. An additional £60 million has been provided to replace waking watch measures with fire alarms in all buildings, regardless of height, or the nature of the building, or the reason for needing the watch. The Building Safety Act puts residents at the heart of the building safety regime, and it gives them a strong voice in the management of their building safety. It ensures all residents are informed about building safety, are engaged in how their building is kept safe, and are empowered to be able to challenge those responsible for their safety. In addition, the department has removed much of the burden for meeting the cost of remediation from leaseholders, as well as improving leaseholders' ability to seek redress, extending liabilities to include associated companies, and extending limitation periods are part of this. This and other work in the department will help ensure that those who created building safety issues pay for them to be fixed, and that the work is done promptly. The department continues to seek pledges from developers, those companies who have profited from the broken building regulation system, to remediate life-critical fire safety defects in buildings over 11 metres in height without recourse to the government's £5.1 billion fund. To date, 45 residential development companies have signed such pledges, and the department actively seeks pledges from others. Whilst the department maintains that the tragedy at Grenfell could have been avoided had those professionals engaged in its refurbishment actually stopped and properly considered the use of ACMP panels and combustible insulation as against the simple functional requirement set down in paragraph B4 of Schedule 1 to the building regulations, a position supported by the closing submissions made in this module on behalf of many bereaved survivors and residents. The department recognises that it too bears the responsibility for failing to take notice of warnings that the regulatory system was inadequate and operating sufficiently poorly such that it would permit such a state of affairs to arise. The department will continue to reflect on the evidence that has been heard throughout Module 6 as it works to reform the building safety system, and will look forward to receiving the inquiry's recommendations in due course. That's the department's closing submission.
Well, thank you very much, Mr. Byrne. Well, that brings us to the end of the oral statements closing Module 6. So we shall rise in just a moment. It only remains me to say that there will be no hearing of the inquiry tomorrow. We shall resume on Monday of next week at 10 o'clock, when we shall hear closing statements relating to Module 4. So that's the end for today. We'll resume 10 o'clock on Monday next week. Thank you very much.